So the people entitled to the notice of a general meeting is every member. In this case, member means those people that has shares. Then every person upon whom the ownership of a share devolves by the reason of being a legal representative of a member. Every director of the company, every auditor for the time being, and the company secretary. And then so the modes of giving notice we have personally, that's when you mail it personally, electronically, by post to him, or his register address by sending it to the address he gave the company. So, according to section 24, subsection 2 of CAMA 2020, as amended, it permits all companies to hold general meetings virtually or compliance with the articles of association. So CAMA permits virtual meetings as long as it is in compliance with the company's article of association. So it's demanded by the chairman, and then at least three members present in person or by proxy, a member or members of a company present in person. Proxy means there's then that right to vote. There are some shares that are not voting shares that does not give you that right to vote. Then company that need not hold general meeting include the private company and a small company. So a private company. So then there's something called the ordinary resolution and there's a special resolution. The ordinary resolution So, the ordinary resolution is passed by a simple majority of the votes cast by the members of the company that are entitled to vote in person or by proxy. Like I said earlier, by proxy is if someone is presenting. It is required for it's required for matters classified as the ordinary business of the company, increase of the capital of the company, and removal of directors. Special resolution members. You know the other one, they just say a majority. This one has to be not less than 75%. And so a special resolution is for the alteration of the business or object clause to change the company name. It's just basically for major businesses, which is not the ordinary business of the AGM. So changing of the company name, probably changing a major policy, reduction in capital, and stuff like that. Then statutory books and record keeping. So there are statutory books that must be kept at its registered office, which is the register of members, register of directors, register of officers, register of employees, register of shareholders, register of creditors, register of customers, register of so the company shall make and deliver to the CSC once every year a return that contains the matter specified in section 419, 418, and 420 of KAMA. A newly incorporated company may make and deliver annual returns in the year of incorporation, but after incorporation, it is mandatory that they make annual returns. So, for the appointment of directors, Kama provides that every company, as long as it's not a small company, must have at least two directors. In a situation when the number of directors of directors, and then maybe something happened to one of the directors, at the end of the day, you should appoint one before the elapsation of 1 month. The employee called the independent director is somebody who, in addition to the general qualification, has in the immediate 2 years before his appointment was not an employee of the company, did not make or receive so was not engaged directly or indirectly as an auditor of the company and all that. So that is for an independent director. Person disqualified from being directors. An infant cannot be a director. A lunatic, a mentally deranged or challenged person. Person that is removed under section 2A So directors are not paid remuneration. They are not entitled. So in the alternative, the remuneration may be fixed by the company's articles of association or the managing director and other executive director are appointed on the basis of their skills, which includes stock, options, bonuses, and participation. They are appointed under a director service contract. So why, as a general rule, directors are not really entitled to remuneration. Managing directors and executive directors are like employees of the company, so they are being paid remuneration. So a director must vacate office if he fails to hold his qualification share, become bankrupt, is found guilty of fraud, becomes of unsound mind, has resigned his office by notice. Then for removal of a director may a company may remove a director by ordinary resolution before the expiration of the term of office, notwithstanding anything in the article or any agreement between. So a company is entitled to removing its director by the use of ordinary resolution. So this part is basically just trying to explain how directors are appointed, trying to explain the management of a company, what it really takes to manage a company. Then duties of a director. They are to observe utmost good faith, they are to observe utmost good faith towards the company in any transaction as they are agents of that company. They are to act at all time in what they believe is the best interest of the company. They had to have the regards to the interests of the company and exercise their power for the purpose for which the company gave them and not for any collateral purpose. They should not accept a bribe, gift, or commission, account to the company for any secret profits made, and all that. So basically, the duties of the director is like a duty of the agent because in this case, the directors are like the agents of the company. So Sorry, give me a moment. So I'm just trying to explain the parts that I feel it's going to be difficult to understand, because this course is basically like a very easy course. As long as you read it, it's easy to understand. So then we have the company secretary and company secretarial obligation, which provides that all company, except a small company, must have a secretary. And a company that has none at the commencement of the act must appoint one not later than 6 months thereafter. So there must be a secretary, and their qualification of a public secretary, a secretary for a company, the secretary must have any of the following qualification. So they are either a legal practitioner within the meaning of Legal Practitioner Act, that's a lawyer, or they are members of the Institute of Chartered Secretary, or they are membership of any professional body of accountants established from time to time. So they are either accountants or they are legal practitioners. Any person who has held the office of the secretary or a public company for at least 3 years before its appointment, or a body corporate or firm constitution of the professionals. So duties of the company secretary, they are to attend the meeting of the company, then they are to maintain the registers and other records required to be maintained by the company under the camera. They are to render proper returns and give notification to CAC. They are to carry out such administrative and other secretarial duty. So removal of secretary from office, a secretary can be removed by the board, and then when it's intend to remove the secretary, it must give the secretary a notice that states that it intends to remove the secretary from office, set out the ground on which it intends to remove him. So we are removing him from office. This is why we are removing him from office. You have at least 7 working days to make your defense. Then you have the option within a period of 7 working days. So the record keeping and filing that should be maintained is one, the financial